morning, everybody. Thank you for joining our session today. It's really great to see all of you here. It's great to have some in-person events again. And I wanted to just remind those of you that haven't signed in yet, the sign-in sheets are at the very back there on the right-hand side. If you don't do it now, remember to do it later. Links to the materials were emailed to you. So if you needed materials, they were in the email that they sent you. And they're also, if you go to this event on the web page, if those of you that have laptops.
I don't know. Has the hotel given you Wi-Fi information? I can't get the materials.
Yeah, I'll have to have, Rosanna's going to look in the packet. We haven't tried to use the Wi-Fi, so I don't know what the link is.
I can't download that.
Sure.
Oh, wait a minute, someone has a Wi-Fi.
And then is that's
Thank you very much.
Attendance certificates will be emailed after the event, and evaluation forms can be dropped in a box in the front desk or emailed later. And with that said, we'll get started. The sign-in sheets are at the very back. Make sure you sign in. You don't have to do it now, but make sure you sign in. And I'm very pleased to have with me as co-speakers today and presenters Justice Teri Jackson. Justice Jackson is the presiding justice of Division 5 in the 1st District Court of Appeal. And also presenting today is my colleague, Rosanna Gann. Rosanna is senior counsel at Hanson Bridget, practicing in intellectual property, litigation, and appeals. And our program today is going to attempt to take a run at about a dozen cases in your materials. There are actually more than a dozen in your materials. We're going to take a run at a dozen cases and talk about those cases that should be of interest to most civil litigators, probably depending on which case we're addressing, some more than others for some of you. And with that said, we'll get started with the case about venue.
Hi, I'm Justice Jackson, and first I'd like to thank you all for having me here. And we're going to talk about cases, and I hope, for me at least, I hope it won't be humdrum. I tend to get into the background of the case, and be it, in fact, one of the particular cases that I will be presenting will add some more light and flavor, color, salacious information to make you appreciate the case a little bit more. But in this case, Malloy versus Superior Court, it's about venue. And it's something that is not only that's going to impact or those who practice employment law, but all of us. Ever since we now allow people to work from home. If I can get a show of hands, how many allow your staff to work from home? Pay very close attention to this case now. Musgrave versus Superior Court. This was written by Justice Perlis out of the 2nd District. He's the presiding justice. Just to give you a little information about Eleanor Malloy, and when I think about her name, I think of Malloy, there's trouble in River City. Well, there could be with this work from home and the law now. Ms. Malloy worked for this company in Orange County, and before we had the pandemic where we all had to do shelter in place, you can go to the next slide, she, her supervisor, if not the owner of this particular company, was doing certain things, asking information about her personal life, making inappropriate comments, but she didn't act on it at that time. Then, as we all know, on March 17, 2020, we all went into shelter in place, and she started to work from home. She had permission from her boss, the person who was making all these comments, to work from home. Everything was going quite well until a year or so, 1 year, and she became pregnant while working from home, and the boss continued to say, you can work from home, you're pregnant, there's not a problem. And During her pregnancy, she discovered that she had some complications. And it was on March 3rd of 2021. Boss knew she was working from home, she was pregnant, but the doctor then said to her, you should not resume work, even at home, until March 10th because of these complications. So of course we're talking about two privileges, or leaves and rights. One dealing with parental rights, and the other when you have a disability as a result of it. And of course these claims started in a FEHA context. So she filed, well, ultimately she filed a pregnancy discrimination, interference with leave rights, and retaliation under FEHA. How did this all happen? Well, on March 3rd, she informs her boss, I'm having problems, I won't be able to come back to work. She has a baby on March 17th. She tells the boss, I have a little boy, everything, is going on, but I'm still gonna have to be off until May of that year. The boss, less than even 3 weeks after the baby was born, calls and says, I want you back to work immediately. She then says, well, didn't you receive a note from my doctor saying that it would be, I shouldn't do it. I have the Parental Leave Act, I have the California Family Rights Act, leave and so forth, that's all in place. And the boss said, nope, you are to return back to work. He then sends her a letter of termination while she's on leave. Under the employment, a letter of termination dated back to March 3rd when the doctor sent the letter saying she has these issues. So therefore she files her lawsuit, and she filed the lawsuit in Los Angeles. Why Los Angeles? Her home was in Los Angeles, where she was working. The boss, or the company says, no, we're gonna go into Los Angeles and do a change in venue because the company is in Orange County. I see people nodding, that makes sense, right? Well, you have to remember when you're talking about FEHA, there's special venue provisions because the purpose of FEHA is for effective remedies for discriminatory practices. So there's a little bit more leeway in terms of venue. Venue can be in the county, in the state where the aggrieved party works, Orange County, I guess that's where the headquarters are. Or it could be in the county where the records are relevant in the practice and all the administrative. That's what the boss said. Hey, everything is here. Our witnesses are here. Our records are here in Orange County. Then it could be in the county in which the aggrieved party would have worked but for the unlawful practice. Justice Prella said she would have worked in her home in Los Angeles, but for your termination, that unlawful practice, because she was on leave under 2 statutes, and she was working, the boss knew she was working from home, and the Justice Prella says she can bring her lawsuit in Los Angeles. Trial court, before it was reversed, the trial court thought it should be in Orange County because that's the company. But Justice Perlis in this decision said it is Los Angeles. The alleged violation occurred while she was at home, she was on leave, or she was working at home. He knew that she was working at home. So venue could be in Los Angeles. What does that do for 372? When you're talking about witnesses and so forth, that's still up in the air. That's still something that the trial court should balance. So where does that leave us here today? Well, folks, we are now in a hybrid situation. We have people who are coming into work 2 days a week and working 3 days a week at home. What do we do when you say to your staff or your clients and so forth, oh, you can work at home? What if that home is your company's up in San Francisco and you work from home down in Los Angeles or San Diego? These are all the things that you're going to have to think about when you have these work from home policies or hybrids based upon this case of Malloy. And Justice Perlis did allude to maybe this should be a part of the employment agreement, similar to where you have arbitration. You know, you agree if there's a grievance and fee blah, 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 that you can do it through arbitration. These are things that maybe you should take into consideration. So, moral to the story, when you say to your staff or to your clients, oh sure, work from home, great. But if the termination is going to happen, remember, venue could very well be where that person works, and that could be home. Are there any questions?
Yeah, we have a partner who works in Santa Fe, New Mexico. So we better not terminate him while he's on some sort of leave, or we'll be litigating the case in Santa Fe, it seems like. But I think the Court of Appeal in that case mentioned that she was on leave in Los Angeles, and the interference was interference with her ability to do her work in Los Angeles. So, I mean, it gets kind of amorphous, right, when we're all on a WebEx call or a Zoom call, and if something goes down during a WebEx call, where is everybody for purposes of the forum? So, the case has a lot of further implications, and everyone should be thinking about that. It certainly spices up venue, but now we're going to move away from that to something.
I'm interested in the forum convenience issue in the case. It seems that one point of view is the gal is working in place X, but if all the other witnesses are in, let's say, Orange County, it would make sense to file a venue motion based on that. I've done that myself a couple times.
And it could as a factor, and it's something to consider, but in this case, it turned out the only witness was the boss, and it was, so I think that they didn't put much emphasis on it at the trial level versus the court. The trial court just said, oh, corporate office is Orange County, end of discussion, and that's how the court made its decision. Justice Perlis did say that is something to weigh, but it wasn't done in this case. And then he pointed out, well, it was just one witness anyway.
I know, but employment records are for this gal are going to be in the corporate office, not in the gal's office.
That's true. It's something to weigh, and in this case, the trial court didn't do it, so they sent it back. So all those things need to be discussed. And it's what about she received her termination at the Los Angeles office. And Perlis did address, well, if you're on vacation in Tahoe and you get the termination letter in Tahoe, obviously that's not going to be venue, and that's not, you can't sue in Tahoe necessarily. So he does do carve-outs when you're on vacation, you're traveling and so forth, because I'm thinking about one of our research attorneys who, for whatever reason, a family member, she was in Europe for 3 months. And the idea that she came back and we weren't going to terminate her, but what if we had a terminator and she's over there in Italy? We didn't have to go over there. So these are all the things you have to think about in the employment context, not only if you were an employment lawyer, but if you were an employer.
All right, we'll transition into the anti-SLAPP statute portion of the presentation. Rosanna?
So our next case is Sanchez versus Bezos. And this is one of the cases with a salacious backdrop. So I do want to go into it because it's interesting for people. The case itself is about anti-SLAPP motions and hearsay. But the backdrop is that in 2019, the tabloid newspaper, the National Enquirer, released an article about Jeff Bezos having an affair with Lauren Sanchez, who he's still with to this day. And they were both still married at the time. So in turn, Bezos, not wanting to sit still, turned around and accused the National Enquirer of being a part of a conspiracy to attack and blackmail him on behalf of the Trump administration and the government of Saudi Arabia. So that's the backdrop of the case. And before we move on, I just wanted to point out that I thought this headline from the New York Post was really interesting because there's actually more than one meaning. So there are allegations that Bezos was sending sex to Lauren Sanchez, and included were some pictures of himself. So you can imagine that's one interpretation. But the second interpretation was that the then CEO of the National Enquirer, his name is David Pecker. So you can see that, I mean, like, we're attorneys, so we love wordplay. And I mean, I was talking to this about Gary, and I was like, I have to put this photo in. It's not directly relevant to the case, but that's okay.
We have to lighten it up, right?
Okay, so the plaintiff in the case is the brother to Lauren Sanchez. He's not only her brother, he's also her manager. So what happened is plaintiff sued Bezos for defamation, saying that Bezos was going around telling news reporters that plaintiff was the one who was responsible for sending explicit photos of Bezos to the National Enquirer. So, I mean, it ended up that plaintiff did admit he leaked some information to the National Enquirer, but he was adamant that he didn't have photos of Bezos and he did not share those photos with the National Enquirer. So in response, Bezos filed an anti-SLAPP motion. And for those of you who may not be as familiar with it, I thought I would explain that the anti-SLAPP statute is meant to protect First Amendment rights. So it's designed to prevent frivolous lawsuits filed by large, powerful corporations or people in order to suppress public speech on public issues. So what happens during an anti-SLAPP motion is, first, the defendant who files a motion has to show that the case arises from protected activity, essentially speech that's on public issues. Then the burden shifts back to the plaintiff to show that the case is not frivolous, essentially that there is minimal merit. And a unique aspect of the anti-SLAPP statute is that once the motion is filed, discovery is stayed. So normally what the court can consider are only the pleadings, declarations, and affidavits. So that becomes important. So essentially after the burden shifted back to the plaintiff, he had to show his case, his defamation claim had minimal merit. And to do that, he offered his own declaration, claiming that numerous reporters had informed him of Bezos' defamatory statements. And so he listed 5 reporting agencies, and he also listed 1 reporter by name. So the trial court was non-precedent and said that those declaration statements were hearsay, and so because there wasn't enough evidence of defamation, the trial court dismissed his defamation claim, or his action. Well, the appellate court agreed as well. So on appeal, plaintiff argued that the hearsay statements should not have been excluded and they should have been considered on the anti-SLAPP motion. He said that there is a reasonable possibility that the hearsay will be cured at trial. And so under the Supreme Court decision in Sweetwater, it shouldn't have been excluded. He said, well, the reporters themselves could be called to trial and testify as to those statements, and so there would be no hearsay problem. But the appellate court disagreed. The appellate court took a very limited read of Sweetwater and said, okay, Sweetwater does create a hearsay exception, but only for statements made under oath or penalty of perjury, because those types of statements are very reliable. Here, because the reporter statements were not made under oath, penalty of perjury, they were just said to the plaintiff, they did not qualify for the Sweetwater hearsay exception. And so the court said what he should have done, what plaintiff should have done, is actually get declarations from the reporters themselves, and then those could be considered on the anti-SLAPP motion. But, so I think the interesting part is if you actually go and read the Sweetwater decision, which is from the California Supreme Court, the evidence at issue were statements under oath. These were grand jury testimony and plea forms. But the court's actual decision and analysis has very broad language. The court says, okay, there's 2 types of evidence. There's evidence that may be admissible at trial. And then there's evidence that could never be admissible at trial, like evidence that's protected by privilege. The court's language was essentially saying that the former category, stuff that may be admissible at trial, it should be considered at the anti-SLAPP stage. So on the slide, I have two of those sort of broad language from the case. The court said to strike a complaint for failure to meet evidentiary obstacles that may be overcome at trial would not serve the SLAPP Act's protective purposes. Of course, the court also said evidence may be considered at the anti-SLAPP stage if it is reasonably possible the evidence set out in those affidavits, declarations, or the equivalents will be admissible at trial. And the court's rationale is that at the anti-SLAPP stage, because discovery is stayed, it may be hard for the plaintiff to achieve like perfect foundation of trial admission. So it would be unfair to hold the plaintiff to that high standard. So I think there is room to argue that the Sweetwater decision isn't just limited to statements under oath to qualify for your exception. It's much broader than that. There was a petition for review filed in Sanchez, but unfortunately it was denied. So we won't know what the California Supreme Court thinks about Sanchez.
So this case is a really big deal for those of you who are involved in anti-SLAPP motions, and so is Sweetwater. Sweetwater basically says it should be a rare day when hearsay stands as an obstacle to an otherwise meritorious claim going forward. And after all, the anti-SLAPP statute is a screening device that occurs at the initiation of a lawsuit. So Sweetwater stands for the proposition that only evidence that can never be admissible, should be taken off the table when a court is doing the prong to analysis in an anti-SLAPP motion and trying to determine if it will allow the case to go forward. What the Court of Appeal here in Sanchez does is it confronts hearsay. It has a declaration from Mr. Sanchez, and in that declaration he says that other people said X, Y, and Z. His declaration is signed under oath. So in theory, his declaration signed under oath is no different than a plea form signed under oath or a grand jury transcript where the testimony is given under oath. So in one sense, the Court of Appeal in Sanchez overlooks that analogous condition. But more importantly, I think, going forward, is the fact that it's probably going to be a rare case that your ability to survive an anti-SLAPP motion or succeed in getting a case dismissed is going to turn on a very limited amount of evidence from one source. And then if that source gets stricken as hearsay, you're out. And that's largely what happened here. But I will say this case, which I think is absolutely wrong, Sanchez, I think it absolutely got Sweetwater wrong, but that's just my opinion. But those of you who are, boning up on Sanchez, you can really press the hearsay issue in your anti-SLAPP motions now. And you can shoot for a more rigorous ruling from the court on hearsay. And you've got actually a case that's excluding evidence on hearsay grounds that, in my opinion, could be admissible at trial. He could go get those folks, he could take their deposition, he could, bring them to trial and have them testify or whatever. All of that remained to be seen, and yet the case was dismissed.
I'm glad that I didn't write Sanchez, but so he agrees with all of my decisions up right here. He's never criticized one of them.
And I'm not going to do it up here.
Here, I kind of disagree though, in the sense of this. That person can never testify to prove the defamation was made. It's got to be the reporter that heard the statement made to him. So you could never cure this plaintiff's ability to prove the defamation through that means. And I made the same ruling before the Sanchez case on a SLAPP motion saying, if you can't just give me a newspaper article that said somebody said something. You have to bring in the reporter that heard it said, the way the person had said it.
No, and that's not, the point was simply this, that he could go get the witnesses, he even knew the name of one of the reporters. So he could go get it. But my point is, does he have to do it prior to filing suit? What method to compel the witness to come to court does he have prior to filing suit? When he files suit, what happens? An anti-SLAPP motion is filed. Does he now have to ask for the stay on discovery to be lifted so that he can do all the things that he would ordinarily be allowed to do after he gets past the anti-SLAPP motion? So anyway, as you can see, there's reasonable room to disagree here, and it's why I think this case and Sweetwater are very important cases for those involved in anti-SLAPP motions. Whatever side of it you're on, there's something for it. There's a lot of room to maneuver now on evidence at the anti-SLAPP stage.
I have a feeling this won't be the last word, so we'll see more.
All right, so the next case we're going to talk about is another anti-SLAPP case, which is Geyser. And you know, a couple of years ago, I was down in LA. I was doing an MCLE presentation on anti-SLAPP with Justice Ruvolo, and Justice Ruvolo opened up the conversation by saying it was amazing to him how finely, how precisely the California Supreme Court was slicing the anti-SLAPP prosciutto. And so here we have some more really fine slicing of the anti-SLAPP statute. And Geyser involves the catch-all provision. And the catch-all provision is 425.16 subdivision E4. And the catch-all provision has to do with conduct in furtherance of the exercise of the constitutional right of free speech in connection with a public issue or an issue of public interest. And that's been euphemistically labeled the catch-all provision by the courts. It was enacted later than the original three positions. And apparently it was enacted because the legislature felt that there was some protected activity that still wasn't able to avail itself of the anti-SLAPP statute. Now, what happened in this case is the plaintiffs lost their home to foreclosure during the Great Recession. And they negotiated with the company that bought the home at a foreclosure sale to get it back. That company was called Wedgewood. And after some attempts to work out a deal to get the house back, they found themselves locked out of the house. Their belongings were removed, and they were out. And so they did what people might do in similar circumstances. They got the help of a housing advocate, and they went to the company's headquarters, and they protested. The housing advocate was a nonprofit that basically was involved in calling out, shady foreclosure practices and other things going on that kind of really accumulated and occurred a lot more during the Great Recession when so many Americans lost their homes. So they had this housing advocacy agency called ACE, and they went to the headquarters and they did some protesting there. And then when that didn't work, they went to the CEO's house. And they had a protest at the CEO's house. And about 25 people attended. And this went on for a couple hours peacefully, and then they left. And after that, the CEO of Wedgewood, which was the company that foreclosed on their home and now owned the home, took out a civil harassment order against the plaintiffs who had lost their home. And they responded and also took one out against ACE, the nonprofit. So they were facing these civil harassment orders, and they responded with an anti-SLAPP motion. And what happened was, the question really before the trial court and then the Court of Appeal, before we get to the California Supreme Court, was this expressive activity conduct that fell within the catch-all provision? Was this conduct in furtherance of the exercise of free speech, and critically, in connection with an issue of public interest? And the trial court came to the conclusion, notwithstanding the protest, notwithstanding the presence of protesters who had no relationship to the plaintiffs, other than perhaps empathy, and so on, that really this was a private dispute. And even though protesting was involved, it was just about the plaintiffs trying to get their home back, which they were still trying to do, or hopeful of. And they had the help of a nonprofit, but it was about getting the home back. And the Court of Appeal actually agreed. And the Court of Appeal actually delved into the motivation behind the plaintiff's actions. And using motivation as sort of the touchstone, it came to the conclusion that it was a protest that was purely personal to the homeowners. And concluded and wrote that it did not address societal issues such as residential displacement, gentrification, or the root causes of the Great Recession. They just wanted their home back. And one of the Court of Appeal justices dissented and basically said it's hard to think of a more paradigmatic case for the anti-SLAPP statute than a case in which a powerful developer obtains the home from the plaintiffs and then files a harassment claim against them when they protest about losing their home and about some of the deceptive practices they used when they were negotiating to potentially give the home back to the plaintiffs who lost their home, to the homeowners. So what this case really came down to for decision purposes was how do courts interpret the catch-all provision? And critically, how should the courts decide whether the conduct at issue is in furtherance of speech in connection with an issue of public interest? And previously, the Supreme Court had endeavored to tell us how to do that. And that case was called Philmont. And in Philmont, we thought we got the last word on how the catch-all provision works. And there, the court had said we asked two questions. And the two questions we ask are, first, what public issue or issues does the challenged activity implicate? What public issue does it implicate? And then second, and more importantly, we ask whether the conduct in the specific case contributes to that public discussion of that issue. That was Philmont. But apparently that wasn't enough because in this case, Geyser, the court grants review to elaborate on Philmont. And the California Supreme Court says that with respect to Philmont's first step, going back to the first step, it's an objective inquiry. Now remember earlier when we were talking about Sanchez, we were talking about how courts end up with these affidavits. And the affidavits are describing the evidence to get past the anti-SLAPP motion. And one thing that courts have been struggling with is what type of inquiry do you make when you're looking at these affidavits? You've got the party trying to establish minimal merit, and you just take their word for everything. And in Geyser, the court says, no, it's an objective inquiry. Yes, the burden has shifted to the party opposing the anti-SLAPP motion to show evidence and minimal merit, but you don't have to take their word for everything. It's an objective inquiry into the facts. And there's no deference to the framing or personal motivations. And then the first step is satisfied, and then the first step again is what public issue is implicated under these facts. So identifying the public issue, the first step is satisfied so long as the challenged speech or conduct, considered in light of its context, its broad context, may be reasonably understood, this is very generous, may be reasonably understood to implicate a public issue. So finding a public issue has never been a problem for the courts. Here's some more elaboration. It's never been a problem. But where the problem occurs, or where cases go one way or the other, is when a court turns to whether that conduct furthered the conversation on the public issue. And here the court says, again, not only must courts consider context broadly, it must also consider any inferences from the facts of the case. And the inferences can be as important as the facts that are alleged in the affidavits. And so looking at, and this is what's amazing about the anti-SLAPP statute, right, in these cases. You have so many judges. You have a trial judge going one way, you have a court of appeal comprised of 3 judges, 2 go one way, 1 goes another way, and then you go up to the Supreme Court and they tell you it's all black and white. It's all so easy, right? And so here, they saw this case somewhat the way the dissenting Court of Appeal justice saw it, which is this was easily a case involving a speech involving the furtherance of a public issue. And as the Supreme Court described it, it said, just looking at the facts of the case, you had a housing nonprofit, housing rights nonprofit, and you had some 24 or 25 members there protesting. Yes, trying to assist them in getting their home back, but protesting, calling out Wedgewood on various practices that they thought were shady with respect to foreclosures for the purpose of flipping homes. And you had the fact, ignored by, apparently by the Court of Appeal and by the trial court, that after the protests had occurred at the CEO's home, Wedgewood's CEO's home, Wedgewood issued a press release attacking the nonprofit, not attacking the homeowners, attacking the nonprofit and describing the nonprofit housing rights organization's practices. So wasn't that in furtherance of a public discussion about foreclosures, about flipping homes after foreclosure, about negotiating for buyback after foreclosure? Wasn't there sufficient facts there to find that the catch-all provision was satisfied? And basically the Supreme Court says, yes, of course there was. The bottom line, I think, here is that courts, and this goes back to something we talked about in the first case, the bottom line here is that the anti-SLAPP statute's not a summary judgment statute, I'm sorry. And it should be a rare case that fails to get past, you know, or a frivolous one that fails to get past an anti-SLAPP statute. And what the Supreme Court is saying here is that with respect to the catch-all provision, it was enacted, it's called the catch-all provision, right? It was enacted because there were incidents of protected activity not available, not able to protect under the statute when it only had the three elements, when it only had 1, 2, 3, and 4, which to do with judicial process, cases in the courts, or cases with supporting cases in the courts, and so on. The statute was amended to catch these other places where expressive conduct wasn't able to rely on the anti-SLAPP statute for protection. And the court here is saying now, when you get to the catch-all provision and you're a court and you're making the ultimate decision, did this dispute, did the speech at issue here further the conversation? What conversation? Well, the larger conversation on an issue of public interest. It says do that very broadly, and give the evidence the benefit of the inferences, and it reversed and sent the case back. A question?
The context of the order was a stay-away order?
Well, what happened was...
It wasn't, the anti-SLAPP motion wasn't filed in a lawsuit per se. It was a standalone order to stop the protest.
The CEO brought a civil harassment measure, and they actually responded with an anti-SLAPP.
Right, okay. So it wasn't, there was a lawsuit pending about the foreclosure, and they filed a...
No. And actually what happened was, when they filed the anti-SLAPP motion, the CEO dismissed his civil harassment petition. He dismissed it. And the context of this case actually is that the homeowners were then entitled to attorney's fees. And they moved for attorney's fees. And the court said, no, I can't give you attorney fees because you didn't prevail. You were just having a private dispute. And your private dispute was about trying to get your home back. So yes, he dismissed his lawsuit. And ordinarily, you'd be the prevailing party because you filed the lawsuit and you got him to dismiss his civil harassment petition. But I can't give it to you because you were just having a private dispute. And that procedure ended up in Geyser, which is all about the anti-SLAPP statute and how to decide whether the catch-all provision, whether the facts in the case actually further the conversation on an issue of public interest. So we'll move to the next one, which is that one, Michael Jackson. And this is Sarova. This was also decided recently, another anti-SLAPP case. And I think Sarova is interesting for a couple of reasons. And one, I'll just start out by reminding people, or maybe those of you that don't handle anti-SLAPP motions that much, the anti-SLAPP statute, right, is 425.16, but there's 425.17, and 425.17 was enacted years later, and it was enacted because basically those involved in commerce were using the anti-SLAPP statute. So, you know, when the manufacturer of widgets got in a lawsuit with the retail purchaser of the widgets, they were using anti-SLAPP statutes. When consumers were complaining about the manufacturer or the defects in the widgets, the manufacturers or the sellers of widgets were using the anti-SLAPP statute. So what the legislature said, and it's ironic, it says in the preamble to 425.16 is this language about there being an abuse of these use of lawsuits to chill public participation. And then when they amend 425.7, they say there's been an abuse of 425.16 by these commercial entities. 425.17 basically carves out a lot of commercial cases if they fit the elements. And it basically focuses on statements at issue consisting of representations of fact about that person's or a business's competitor's business operations, goods or services that was made to promote commercial transactions or was made in the course of delivering the person's goods or services. And the intended audience is an actual or potential customer or person likely to influence a customer. So basically the legislature was trying to claw back these commercial disputes from availing themselves of the anti-SLAPP statute, but it was worried. And so it created an exception to the exception. It created an exclusion for artistic works. And I bring this up because if it's an artistic work, you say, well, you know, you're making records, it's commercial, but it's an artistic work. So 425.17 does not apply. I bring this up as a preamble because it's important to know about 425.17, both what it tries to claw back from the anti-SLAPP statute and what it still protects in terms of expressive works. And it's helpful to know about that in the right kind of case. Now, this case just involved 425.16. And the question here was whether Sarova could sue Sony over Sony's representations that all the tracks were sung by Michael Jackson. And Sony basically attested or put in the jacket for the album. You know, these are 9 Michael Jackson's tracks, never before, you know, published Michael Jackson tracks. Before the album was even released, there was a dispute, and it was in the media. Even members of the Jackson family were saying, no, that's not Michael. 3 of those songs, that's not Michael Jackson, that's not her brother. And so on. So there was already a public conversation about this album and those 3 tracks before Sarova sued. Sarova bought the album. She, exactly when or why, but she became annoyed or whatever that the 3 tracks don't appear to be Michael Jackson, or she didn't believe them to be, and she files her class action lawsuit on behalf of everybody who purchased the album. The trial court rules that targeted speech is protected because there's a conversation going on about Michael Jackson as artist, about Michael Jackson as actual singer of the 3 tracks, and so on. And the trial court says that there is protected speech here. Sarova is attacking protected speech, but it's commercial speech. It's commercial speech. So the trial court says, I get you, Sony. There is protected speech here. You're advertising, you're talking about an artist. This is all interwoven here. Commercial speech, artistic speech. Sony says, hey, it's all artistic speech. But the trial court said no. Said this is actually advertising. And so the trial court wanted to allow the case to go forward, deny the anti-SLAPP motion. And the Court of Appeal reversed and said no. This is all artistic endeavor. This is all artistic endeavor. Obviously, it's a Michael Jackson recording, it's an album, it's music, it's art, right? But more importantly, there is this public debate going on about whether or not Michael sang the songs. So this is not advertising, this is just artistic expression about Michael. And so because it's directly connected to music, it enjoys the full protection under the First Amendment. And concerning a publicly disputed issue, making direct claims on the controversy itself, it dismissed her lawsuit. And again, this is an interesting case because of the disparity here. You know, commercial speech is not immune from false advertising claims. Never has been, right? It goes back decades. And the California Supreme Court takes the case and basically says, the only time we would entirely shield this type of speech is if it's so intertwined between art and commercial speech that there could be no untangling of it. And then the court says, but this is not that case. All Sony was trying to do with its promotional video and with its the back of the album, the jacket, describing these never before released Michael Jackson tracks, his vocals, was to sell albums. They were only trying to sell albums. So the trial court was actually correct in saying this is a false advertising case. And ironically, all the debate about whether or not it was Michael Jackson, I mean, it was on Oprah, it was everywhere. But all the debate about Michael Jackson only went to show that there certainly was a claim with minimal merit and should have gotten past the stage prong 2 of the anti-SLAPP statute. I'm not sure why the Court of Appeal refused to allow the case to go forward. Because there are cases where, many, where the party filing the anti-SLAPP motion is correct when they say, hey, they're attacking my protected activity. Sony filed an anti-SLAPP suit, hey, this is an album, it's artwork. We're in the business of producing art, and they're suing us for that, right? Prong 1. Show that there's a public conversation, show that the interview and the video and the Oprah session are furthering the public conversation, and hey, I should get my anti-SLAPP protection. But on prong 2, what about the fact that it's advertising? What about the fact that it's advertising? And basically the Court of Appeal said this isn't, or the Supreme Court said this is not a case. This is not a case. There are some where the commercial aspect is so minimal and so intertwined that we just say hands off, it's art. But this was not that case, and in fact, to the Supreme Court, it was black and white that the case should have gone forward. So our Supreme Court telling us once again that something's black and white that other very able jurists come to an opposite conclusion on. And I will say this, you know, there's for all of you that are involved in anti-SLAPP motions, dig a little deeper, work a little harder, and every week it seems new anti-SLAPP cases come out in the Court of Appeal, right? It's never ending, and occasionally from the California Supreme Court. So stay abreast of the law.
Evidence. This case of Jane Doe versus Bright Star Residential, and I must say that this is, I'm not going to say concerning, but it is being well discussed among my colleagues and various other evidence gurus. This case dealt with Bright Star was a residential program or housing for those who were developmentally challenged. The plaintiff lived there in this residential facility, and she was 20 years of age. However, she basically had a mind of a 6-year-old. Bright Star handled a handyman to work there from time to time. He was an independent contractor. Unfortunately, this handyman sexually molested Jane Doe in this case, and her parents sued on her behalf for negligence and for negligent hiring, negligent supervision, various negligent training. The Bright Star moved for summary judgment, saying that we did not have a duty, this was unforeseeable. And the plaintiff submitted, the court found in summary judgment the burden shifted. Plaintiff submitted, of course, the police report in this case. And the trial court saw the police report with all that hearsay and excluded that evidence, and summary judgment was granted. Case goes up on appeal. The Court of Appeal, there are many issues in this case, but dealing with the evidence and the police report. The police report contained the following, according to the Court of Appeal. One, an admission. One of the owners said to the officers, the police officers, that the handyman had been lurking around. That goes to knowledge. Did he foresee this? And so one of the owners acknowledged to the police officer in the police report that yes, the handyman had been lurking around, and we caught him on the premises at all hours of the night when he shouldn't have been there. The police report also contained employee statements saying that the owners knew about this handyman and that this handyman would look at the residents and would be in unauthorized locations. All contained in the police report, where the trial court excluded the police report as hearsay. The Court of Appeals dealt with the following and said, police reports are often inadmissible. As a former trial judge, I often said that. Police reports are inadmissible, even though it's coming from an official agency, because the information is coming in from an unreliable source. You have witnesses who might be saying double hearsay, and I think this is happening. All of those things are in a police report. Court of Appeals said, not necessarily. And Court of Appeals said the police report in this case should not have been excluded. And you have to take it step by step. First, the statement by the owner of the residential property, or the Bright Star, his statement to the officer is an admission. Party-pointed admission. Then the court went on to say his statement in the police report itself, is an official record. And that's all he said. Then, as to the statements by the employees about their knowledge and what the owners knew or should have known, the Court of Appeals said, well, those statements are not for the truth of the matter asserted. It's to prove the owner's knowledge. So that should have been considered, but they were contained in the police report. And again, the Court of Appeals said the police report is an official record, and therefore it has passed the hearsay exceptions. I know, I see Justice Rivera. You can imagine what Justice Simons is saying about this case. So, the bottom line is, ordinarily police reports, albeit it's from an official agency, but there is that inherent reliability component. And normally, as a trial judge, mine being a former trial judge, Judge Rivera, we probably would have said excluded. But this second district decision said no, that it's an official record, and inside the official record could be exceptions to the hearsay rule. Now, caveat, this was at a summary judgment stage, which really shouldn't be any different than what would be admissible in a trial. Whether this would make it in a trial, I don't know. But it does give us some concern here. Or I'm not going to criticize, but it has some concerns on how do you treat this. And I'd like to get some feedback Yes.
Did the Court of Appeals say this can be cured at trial? You know, to take sort of the Sweetwater type approach and say, well, you know, we're gonna let this get past summary judgment because we know that we're gonna be able to get this in at trial and so on.
No.
Did it talk about that?
No, it did not go there. And I don't know if they were making that distinction because it's at a summary judgment, which you really shouldn't, because the same evidence that should be admissible at trial should be admissible at summary judgment. But they didn't make that distinction.
So they didn't say, well, the police officer can come testify and that cures the second hearsay problem.
No. Yes.
I guess my question would be, had this been just a regular business, not an official business, okay? The business had been recording things that were said by employees in 1270. You'd have a two-level hearsay.
Business record.
They said what they did. They said the first level, it would come in as an admission, the other thing. And the second level is the official record or business record.
Business record, you're
I
trying.
don't have a problem with it.
Well,
But
yeah.
But the police report typically, when the officer's recording it,
So the issue usually the police reports is the conclusion about this is the accident, this person committed a felony. That's opinion, and that wouldn't come in either way.
but even under a business record, the information that you're receiving for business record purposes, and there's that fifth prong, if I'm not mistaken, is it inherently reliable? And the people who are reporting into that, that's their duty, responsibility, and that's why there is that exception under the business record. And so you go through it, it's, you know, was it done at or near the time that the information was received? The person who's recording it, is that his or her responsibility, or is that the custodian record? Then the information that is received, is it in the furtherance of the business? And then that last prong would be, God, I hope I'm telling that Mark Simon. And the last prong would be the inherent reliability. That's why the business record is so different than official. Official records, we think of birth certificates, marriage certificates. Again, it goes through that kind of, it's a business, this information that's being recorded. But a police report is recording what is said. And the reason why so many of us as trial judges, or for me, why I say, yes, it's official, but the reliability, the information that's being in there, there's some question about it. However, this has now shifted that, and maybe I've been wrong all this time, I don't know.
The only question about the reliability is, are you saying that the police aren't reliable in reporting what's told to them, or the witness telling them it's not reliable?
It's the witnesses,
So the issue here is that these are employees or the owner of the business. He's simply taking down what the owner admitted to him. It's not a question of like an eyewitness saying the guy was there. He might have some motivation one way or the other. I'm recording his statement. That's my question.
It could be, and that's probably what was happening, but I don't know. There's a little concern about that. Now, of course, the owner, that's a party appointed admission. The employees, or what if it hadn't been employees, or just anyone, that's where it's going to be a little issue. It's going to be an issue. But now we have the second district published opinion that says, stop trial judges, myself and only a trial judge, don't, every time you see a police report, don't just say, double hearsay, it's excluded. Go through this analysis.
Well, that can't hurt, right? I mean, Justice Simons once told me that when it comes to evidence, there's two kinds of lawyers. Those who, and judges, those who will struggle with it and are struggling with it, and those who are just never going to get it. And he gave me the weirdest look when he said that. Still never been able to figure out exactly what he meant there. But you know, I do think it's worth struggling over. And I'll just close this one out by saying, you know, one thing that those of us at least that are not in court every day dealing with hearsay objections, we sometimes start reaching for the exception, right? Somebody objects, hearsay, and we reach for the exception. But the first question should be, is it being offered for a hearsay purpose? And we sometimes forget that.
But the bottom line, official records, if it comes in for official record, it is being offered for the truth. That's the issue. And then when it applied to the owner, party appointed admission, The other is where I'm having some problems grappling with, but again, the Court of Appeals made that distinction about the employees not for the truth, but just showing knowledge of the owner.
Go ahead, Rosanna.
Okay. So our next case is another evidence case. It's People v. Jenkins, and it's about used cars valuation and public compilation. So this case I thought was kind of sad, just because the defendant seems kind of not very bright. So the defendant broke into a car, used the garage opener in the car to open the garage, and then he went and broke into the garage. Well, the homeowners were home at the time, so they came out and told him to leave, and he did. He was arrested shortly thereafter, and they found that he had stolen an iPod and some containers with coins. So for all of that, he got a whole bunch of charges. He got burglary of vehicle, burglary of residence, possession of burglary tools, and also a charge of attempted unlawful taking of a vehicle. And some, he got 13 years. Yeah, so that's pretty sad. And what's even more interesting about this appeal is that his appeal for this, he contested the conviction of attempted unlawful taking of a vehicle, but even if he wanted to appeal, his sentence would not have changed because he got 13 years for burglary charges and he got a concurrent sentence for this charge. So it's a little unclear why he took this appeal. In any case, for this charge of attempted unlawful taking, the vehicle value has to be above $950. So from the prosecution side, they had a police detective rely on the Kelly Blue Book to come up with the car valuation. And this detective used the Kelly Blue Book quite often, but he didn't know how it was created, how the information was collected, and also he didn't know how its pricing methods were used, what kind of pricing methods it used. So the defendant said that, well, the car valuation is hearsay, so it should be excluded. The trial court did not agree. It said that the valuation is admissible under the published compilation exception. So the appellate court
People, I see someone, what is it?
So I can go through the final pretty quickly. Actually, I didn't know about this exception either for this case.
But the judge didn't.
So the appellate court agreed with the trial court and said, okay, the published compilation exception has 5 factors. It must be a statement from a compilation, the compilation must be published, it must be generally used, and it must be generally relied upon, and finally it must be a statement of fact rather than opinion. So the court said, well, yes, it's obviously a compilation and collects a bunch of pricing on used cars based on like make, model, where it's sold, and also condition. Factor 2 was not disputed. Factor 3 and 4, the court relied on the police detective saying that he used it, he knew car dealers that used it, and he also knew that consumers used it quite a lot. Okay, and then so at the end, the court also said specifically that you don't need to know how that compilation was made in order to rely on this exception. So I think that's pretty straightforward.
And you all learned publishing.
One thing I was going to say is that there are cases out there now, reported cases, where online databases have been described and found to be published compilations under the evidence code. And one very famous one is called Identidrug. And the Identidrug database or website is used by police officers and other law enforcement agencies to identify, for example, if they arrest somebody and they find a little satchel full of pills, it's used to identify those pills. That database has withstood the judicial rigors of review for whether it satisfies the published compilation in section 1270. So I'll leave you with a thought. I'm not really sure the answer, but appraisers always used comps to evaluate the value of a particular property by looking at the value of other properties. So now when I go on Zillow, if I'm an appraiser and I go on Zillow and I see all these properties there, and I look at them and the numbers look good to me and they seem like within the realm, is that a evidence code 1270 published compilation? Is Zillow a published compilation? And I think it might be. I think it might be in the right kind of case. And it's generally used and relied upon. So if other appraisers are using it, if other appraisers are relying on it, if the characteristics of Zillow are such that it's created in the furtherance of a business and blah, 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 it might qualify in the 5-factor test for Evidence Code 1270. So I'll leave you with that thought. What other things out there that we turn to online are now Evidence Code 1270 published compilations?
Justice Rivera?
I really struggle with the fact that a statement of value is a fact, not an opinion. I mean, I get a drug, that makes sense. It'll this or it's not this. But how much a car is worth, how much a house is worth, that's an opinion. Until you have a sale. I mean, comps are based on actual sales, not based on something Zillow has put up on the computer saying that we think this house is worth X, Y, Z.
Yeah, what's interesting about the Identidrug cases is it's all based on characteristics. So you have a database that's collected that this certain opioid has this color, this shape, this other. Well, cars are a certain model, a certain size, a certain shape. So I'm not saying I necessarily like the idea of a kind of slippery slope here on published compilations, but if Identidrug qualifies, what else qualifies? That's what I'm throwing out there.
One question I had about the discussion of the case was, you walked through and said, here's what they said about factors 1, 2, 3, and 4. What did they say about 5 in that opinion?
Oh, okay, so for that factor, what the court did is it looked at other stuff that had qualified for the exception and then found it was similar. So it looked at mortality rates charts and also commodity rates charts and said, well, it's quite similar to those which are accepted as falling under the exception. So you look at a bunch of factors and then based off those factors, you find like a value. And so based off that, the court said, okay, well, I think it's a statement of fact, not an opinion.
You know, right when you think you know evidence, you learn something more, right? I see another hand.
Yeah, isn't there a distinction there? The Identidrug database deals with a subject that is static, whereas Zillow and car appraisals and what have you, they're dealing with factors that change over time, and sometimes quite rapidly. And it happens that Zillow doesn't necessarily publish when they are valuing things. And in point of fact, the scuttlebutt is that they're usually 3 or 4 months behind the market, and the market is changing very rapidly. Doesn't that nature of changeability take it out of the compilation?
I mean, that's not one of the factors that's considered. I would say, like, there was another wrinkle to this case that was interesting, is that at trial court, the prosecutor argued that it was, well, the Kelly Blue Book is machine, and it's at a number, so it's non-testimonial, and it shouldn't even be like a hearsay problem. But unfortunately, the argument wasn't advanced at the court.
There's another hand. Yes.
I wonder if the reason this case went the way it did is all the court has to find is that the attempted theft was something worth more than $950. So if Kelly Blue Book says the car is worth $5,000, well, maybe it's debatable, but it's probably not debatable that it's only worth less than $950. Whereas if it matters that the court establish an actual value in a case, then maybe it's not admissible, or it's not at least determinative, because there are many sources that would be able to determine what the actual value is, and that's going to be an opinion.
I think if it was a closer case, you're right, maybe it would make a difference. And I think in this case, the valuation from the Blue Book that they got, the lowest possible valuation was like 1,500 to 2,000. So they're like, I mean, that could have affected the way that the case came out.
I have a 1999 Saab, red Saab convertible that I still drive around, so it's 23 years old. Kelly Blue Book says it's only $500. I was at Safeway this weekend and got an offer for $5,000. Okay. But no offers for folks. I'm still driving.
I'm sorry, just one comment. I haven't been on the property for a very long time, so I could be wrong on this. But my understanding of Identidrug is you can use that for probable cause and for binding over, but you can't use it to prove the actual drug in court for probation.
Sure can. Well, it's been 3 years since well, no, more than that for criminal, but you couldn't use it to prove the case. No.
Never.
For probable cause, all hearsay can come in there,
Binding over, yeah.
but
Never,
not for the trial itself.
This one, probably.
Musgrove. Okay, Musgrove. Let me give you a little background on this, a little bit. This was a result, or everybody was down in Bora Bora because of Jennifer Aniston. In 2015, she got married. She got married first in Beverly Hills, then went and invited all of her friends and family to Bora Bora to have the second wedding. So Joel Silver, who is a big producer, he produced The Matrix and Jumping Jack, and I can just go on and on and on. He was one of the invited guests. And what does an invited guest do when you're going to a wedding? You bring your family, you bring some of your friends, and you bring your personal chef and your executive assistant. So there it is in Bora Bora. Now, of course, but for the chef was hired to, or was paid to be there, and he said, you're not there on vacation, you're there to cook for us for our breakfast and our dinner, and if we don't like what Jennifer is serving at her wedding, I want to have you bring over the special food for us. His executive assistant, he said, look, if you would like to join us in Bora Bora, I will pay for your trip, you will have a great time, maybe 10% of while you're there will be there to arrange for any recreations or any events, but the majority of the time you're on your own. So his executive chef goes down to Bora Bora 3 days before Joe Silver and the family and the executive assistant arrive. And while they're down there, while he's buying the food, he's buying the liquor, he's buying everything, the appetizers, stuff for appetizers, he is communicating with the executive assistant, I guess they're friends, maybe more than friends, and the executive assistant, Musgrove, sends a text, have you found the candy? Executive chef said, no, I haven't found the candy, but I found some great herbal things. So, what do you think candy meant? Cocaine. Cocaine. And the herbal was marijuana. So when he sent back the text before she arrived, now I can only find some herbal. She says, you gotta find the candy. And then he sends back, I found the candy. So, Joe Silver, family, friends, all fly down. Everyone's having a good time. They're wishing Jennifer Aniston best wishes. Well, we know how that happened. But anyhow, executive assistant Musgrove and the executive chef, they party one night. And they're drinking, and the alcohol is provided by Silver, because he bought it all. And they're having a great time. They're doing their candy, they're doing their alcohol. Then she goes back to her room, and her room, or whatever you call it, overlooked the ocean. You can look down. And she decides she's going to do a midnight swim. And unfortunately, she drowned. And they found her body 2 days later. And her family sued because of the employment and saying, look, she was killed in the scope of her employment, and more importantly, that your executive chef who worked for you was your chef. This was in the employment, therefore you are liable for his conduct. And the moral to the story is that no, the chef was brought down to cook only. And that Silver did not know he was brought down to provide the candy, the cocaine, or the alcohol. And the late night activities were beyond the scope of his employment of being an executive chef. And Silver had no control over him. And that this injury, this activity of swimming late night, having alcohol, was not a part of the employment. Of course, the family said, but she was there doing 10% of her work. Again, the court said that 10% had nothing to do with her swimming, having cocaine, and indulging or overindulging in alcohol. So this is about what are the duties and activities that are related to the employment, and the executive chef was there to cook food. She was there to arrange activities, but lo and behold, the employment did not involve, you're going to do cocaine and alcohol. So the case was basically dismissed. Any questions?
Isn't it foreseeable that they'd be doing that kind of stuff?
Foreseeable that the chef, they did not have any evidence that Silver knew that his chef and the executive director. Now, are you saying is it foreseeable when an employer has a retreat with their employees that, there's going to be alcohol and overindulgence?
Yeah, that's what he said. He's saying, come on, it's Hollywood.
Right.
That's what Prosser taught me, a long time ago.
Well, the whole point was that it was done after hours, midnight, and they were able to show Silver didn't know there was a relationship between the executive chef and his executive assistant. So if there had been more information that Silver knew about this candy business and so forth, it might have been something that they could say, this is foreseeable, but no. So every time you go on a work retreat, are you saying that, okay, you have swimming pools, alcohol, there's going to be something going on now. But moral to the story is that when you take your executive chef and your assistant, make sure that they go to their rooms when everything's open.
Okay, so the next two cases we're going to talk about are arbitration cases. These two cases come as a pair. So the first case is Morgan v. Sundance, and it takes place in the U.S. Supreme Court. And it relates to motions to compel arbitration and legal capacity. So in this case, the employee sued the employer for violating the Fair Labor Standards Act. And in his employment agreement, there was an arbitration clause, but he brought the case in the Southern District of Iowa. His allegation was that the employer was fooling around with their timesheets and making sure that they never hit overtime, so they never got their overtime paid. So initially, the employer defended itself in litigation and filed a motion to dismiss, and also filed affirmative defenses. But then 8 months in, the employer moved to compel arbitration under the Federal Arbitration Act. And so, the employee argued that that right had been waived because the employer took too long. So at the district court level, the court applied a circuit precedent on waiver, which asks whether the party moving for arbitration acted inconsistently with that right, but also whether there was any prejudice to the other party, the non-moving party. District court found that there was sufficient prejudice and denied the motion to compel arbitration. Then the appellate court disagreed and said there is sufficient prejudice and sent the case to arbitration. The Supreme Court then said, okay, you guys are both wrong. I'm going to reverse and remand because you applied the wrong test. So what the Supreme Court did is it really surveyed the issues in this case and said, okay, there's actually a circuit split. In 9 of the circuits, the courts have created an additional requirement when it comes to waiver of the right to arbitration. There's a prejudice requirement, and this is grounded on the rationale that there's a strong federal policy favoring arbitration. But there's 2 circuits who have rejected this additional requirement. And then the Supreme Court traced this prejudice requirement to a Second Circuit decision from 1968, and then found that it just kept spreading after that to circuit after circuit. And then so after establishing that this is a widespread and long-standing precedent, the Supreme Court unceremoniously shut it down. So the Supreme Court said there is no prejudice requirement to waiver. In any other circumstance when considering waiver, we don't have a prejudice requirement. And so it said federal courts may not devise novel rules to favor arbitration over litigation, including an arbitration-specific waiver requirement. And so the court remanded so that the waiver inquiry could be focused on the employer's actions. Well, I'm going to keep going and you have questions after I finish this next case because...
So that was the U.S. Supreme Court?
Yeah.
And now we're going to the California Supreme Court.
Right, and so this is Quash, I don't actually know how to say this, Quash or Quash versus California Commerce Code. And so this case is quite similar, but it takes place in California State. So it's another employee versus employer action. Sued for, okay, so the employee worked for this casino, the defendant, for 29 years, and then he was fired, and so he sued for wrongful termination, age discrimination. So for 13 months, they fought this out in court, and there was a bunch of discovery, there were a bunch of meet and confers, and the employee's deposition was also taken. After all that, the employer moved to compel arbitration, saying that they had finally found arbitration agreement. And so the employee said, no, you waived it because it's been such a long time. The trial court did find that there was waiver. It found that by engaging in months of extensive discovery, this was inconsistent with the right to arbitrate. And also found that the delay caused prejudice by requiring the employee to spend time and money in litigation. So the appellate court disagreed. It found that there wasn't sufficient prejudice because the employee, the money that he would have spent, that he had already spent in litigation, he would have also spent in arbitration, and held that waiver does not occur by mere participation in litigation. So you can see that there's a big difference in the last case and this case. So in the last case, which is a U.S. Supreme Court case, Morgan held that under federal law, prejudice just does not matter to the employer waiver of the right to arbitrate. And here in Quash, it held under California law, and not only is prejudice a critical factor, it also requires that there's actual negative impact. So it's questionable. There is a petition for review filed in Quash that's been granted, and I think the briefing is almost complete. So the specific petition asks whether Morgan's reasoning should apply here in California court.
And I think First District, if I'm not mistaken, we did something in fact, I think I was on the panel. So I think it's, we disagree.
Oh, did you?
So I think that's what's going on right now, why petitions right now. Yeah.
Did Quash involve the FAA or just the California Arbitration Act?
It was California arbitration.
Yeah, so you do have the possibility of a different rule, and that's not anything new with respect to FAA versus CAA. And you may have a decision from the Supreme Court that says in an FAA case, obviously this, but in a CAA case. That doesn't seem to make a lot of sense because it's the same thing, right? Can you still get the case back to arbitration even though you litigated?
But in this case, the Supreme Court expressly said that they granted review to consider whether to apply the U.S. Supreme Court decision.
That's right. Yeah. And so uniformity would be good. We're going to turn to a Brevet Doctrine case now, Justice Jackson.
Okay, sure. This is out of the 3rd District, and it's written by one of our newest justices, Miller versus Roseville Lodge. And the defendant was hired an independent contractor to move an ATM that was in its lodge. The plaintiff, the employer of the independent contractor, well, give you a little background. So the ATM was in the bar area of this lodge, and there was a scaffolding, and they don't know how it got there, if it was by some other group of people working at the lodge. So when the independent contractor came in to look at the ATM, they realized that they were going to have to go up into the ceiling to deal with some wiring to see why the ATM wasn't working. The independent contractor and his employee, Mr. Miller, they didn't bring a ladder with them. So they saw this scaffolding and they turned to the bartender who worked at the lodge and said, is this yours? And the bartender says, I don't know, it's here. And they said, well, can we use it? Bartender says, do what you want. And there's a dispute as to the bartender saying, oh yeah, use the scaffolding because it's safe. That's what Mr. Miller said, who worked for the independent contractor. Well, they used the scaffolding and they didn't check the wheels on it where it wasn't locked. So as he climbs up on it to go into the ceiling, what happens? He falls and he injures himself. So Mr. Miller the employee of the independent contractor, is now suing the lodge and the bartender. And a motion for summary judgment was made in the trial court where the lodge and the bartender saying, no, prevent. We turned over all of our responsibility to repair and to work on this facility to repair the ATM to the independent contractor. We are not responsible under prevent. And this is where it gets a little interesting because there is a case out there that said where the hiring company or the owner says to the independent contractor, we would like for you to use our equipment. And the employee of the independent contractor becomes injured because they're using the owner of the property's equipment, then of course the owner would be liable. So in this case, Justice Earl said, well, the employer had the scaffolding there. They didn't say you can use it, they just allowed you to use it. So you used the scaffolding, you chose to use it, therefore the owner is not liable. So they were making the difference between we would like for you to use it, recommending that you use it, versus it's there and we will allow you to use it. And therefore you will not, owner, be held liable. And the exceptions to prevent did not kick in. So it's really about what the owner said. So the bartender said, I never told them that they should use it. I just told them it's there and if you want to, okay, you can use it in your work. If the bartender or the owner of the lodge had said, we would like for you to use our scaffolding, then they could be held liable. So, I guess you basically tell your employees, be careful what you say about your equipment. And so therefore, prevent applied. That the delegation went to the independent contractor, and the independent contractor, he was responsible, but not the owner of the property. Does that make sense?
Most of the prevent cases, as the tort lawyers probably know, are disposed of at the summary judgment stage. And so it's interesting that if there had been a disputed fact about what the bartender said, or perhaps some dispute over his authority to say it, what he said, maybe you have, you squeak by as the plaintiff and you get past summary judgment. But in this case, it sounded like there wasn't that gray area. And so the case McCown, she's referring to, Justice Jackson's referring to McCown versus Walmart, is the case where if the owner, the hirer, insists that certain equipment be used and provides it, that opens the door, and that didn't happen.
Well, in McCown, the owner said, we would like for you to use it. They didn't demand it, and the court said that's the exception to prevent. In this case, and I think everyone agreed to this, that no one said you shall use that scaffolding. It just, the bartender said, it's there, you want it, it's yours. So that's, and it's really about being very careful, and I want owners, the property owners to understand that they have to be very careful as to what they say in terms of delegating responsibilities and not saying use my equipment or I would like for you to use my equipment and so forth. Pretty straightforward.
And you know, the contractor who arrives to do the job ought to have equipment.
Well, there was a question about why didn't you look at the wheels on the scaffolding to see if the wheels were locked? That's all it took. So when he was climbing up, the thing goes and he falls over, unfortunately.
So what we're going to do is open it up to some questions now. There's no, it's up 11:30. Officially, this is the end of the session, but we have a few minutes and we're happy to take questions if anyone has any about any of the cases. Otherwise, thank you so much for attending.